To Boulder County Senior Law Day 2020. Today's webinar is on fiduciaries' roles and responsibilities. Before we get started with our speaker, I do have a couple of announcements and housekeeping things to address. First of all, we are, I'm sure as all of you are aware, in a new virtual format. Some things are a little different today. Today's webinar is being recorded. The video will be available later on the Boulder County Senior Law Day website. I've put the link to that in the chat. So you can access that link directly in the chat. Otherwise, it's bouldercountyseniorlawday.org. The host has muted all the participants. Please remain on mute unless the speaker invites you to unmute yourself. If you have questions during the presentation, you can put your questions in both the chat as well as the question and answer function. The speaker may choose to address your question during the talk or may take your comments at the end and address it at that point. We do have a few more webinars coming up. We're about halfway through today. Our next one is this Thursday from noon to 1. John Estes of CAPSAC Law is going to be talking about long-term care and Medicaid issues. Really something that affects so many people and so few people know anything about it. So it's going to be really helpful to listen to John's expertise on that. Our final session is October 1st. And following that session, we have a fun bonus seminar on estate planning train wrecks. So you can sign up for any of these presentations on our website, bouldercountyseniorlawday.org. Again, a link is available in the chat. One of the downsides of going virtual this year means that we are unable to have our usual Ask a Lawyer program. However, we are so lucky that our platinum level sponsor, the Boulder County Bar Association, earlier in this pandemic, set up a free legal clinic so that people can access some of those same services. Callers are paired up with attorneys for brief legal consults on a variety of issues. So if you are missing that Ask a Lawyer and have a burning legal issue that you've been wanting to discuss with someone experienced in that field, you can contact the Boulder County Bar Association at 303-440-4758, or you can go to their website. They have an online form as well at boulder-bar.org. That link is also in the chat. Finally, we have our senior law handbooks. We have made these available online. The Colorado Bar Association published this at seniorlawhandbook.org. That link is in the chat. We also have a limited number available in the old-fashioned hard copy version. To get one of those, contact Erica Corson at the Boulder County Area Agency on Aging. And the number to reach her at is 303-441-1170. And finally, we just want to say thank you to all of our sponsors. We could not be here without them and without their assistance. So many, many thanks to all of them. And with that, I am so excited to introduce our speaker today, Ann Jorgensen. She is the managing shareholder at Jorgensen, Brownell, and Pepin, PC. She practices in the areas of estate planning, trust litigation, probate, conservatorships, and guardianships. In addition to that, she handles matters involving Veterans Administration aid and is an accredited attorney by the U.S. Department of Veterans Affairs. Always creative, genuine, and tenacious, she makes every effort to meet the various needs of her clients. Anne believes that educating her clients empowers them to make better informed decisions for themselves and their loved ones. And we are very lucky that she is here to educate us today. So with that, take it away, Anne. Thank you.
Thank you, Brett. Just going to pull up our PowerPoint presentation. Okay, so I will see if the chat comes up. Okay, oh, I'm asking.
Oh, I don't know.
Okay, all right. Well, today we're going to talk about serving as a fiduciary, whether it be medical or a financial. We're going to talk about roles, responsibilities, and pitfalls. I am an elder law attorney here serving Northern Colorado. We have offices in Longmont, Broomfield, and Loveland. So the first thing we're going to talk about is the fiduciary itself. A fiduciary is a person or an organization that owes duties to another, and they owe a duty of good faith and trust. It is the highest legal duty of one party to another, and a fiduciary must act in the other party's best interest. So a fiduciary can be a number of things. It can be an agent under a power of attorney, whether it be medical or financial. It can be a court-appointed guardian or a court-appointed conservator. It can be a personal representative, or the term that we used to use was an executor, someone that's appointed by a last will or a court. It can be a trustee, someone that's working on behalf of a beneficiary of a trust, or it could be a custodian under the Uniform Transfers to Minor Acts. All of those people are fiduciaries. So any of those people have a duty to another person. They're acting for someone else's best interest. Today, we're going to focus on the first two, the power of attorney and the guardianship and the conservatorship. We're going to use some common terms. First is going to be the agent under the power of attorney. That's the person that acts on behalf of another. The person that they're acting on is the principal. Most people like to say, I'm the power of attorney for my mom, or I'm the PoA for my dad. Here, we're going to use agent as the person that's acting as the power of attorney, and principal as the person that is they're acting on behalf of. A court-appointed guardian acts on behalf of the ward. That is the term that the court uses. Essentially, that would be the same as the principal for a PoA. And the guardian handles medical issues, where the ward will reside, and replaces the medical PoA. A court-appointed conservator acts on behalf of a protected person. Again, that is the term the court will use. The conservator handles financial matters and replaces the financial PoA. For simplicity, we will simply refer to the principal for all of these designations. The issues that affect primarily court-appointed guardians and conservators, you'll see those marked as G and C. For issues that affect primarily agents, those points will be marked with the term agent. If there is nothing on there, then it essentially affects all of the roles. Fiduciary responsibilities. The law states what duties are owed. Now, a document, like a power of attorney document, can modify or impose additional duties. So you need to be aware of what the law states, and then you need to read the document. The document is very, very important. You need to I would suggest to my powers of attorney that read it at least once a year. When you first get appointed, read it a couple of times, highlight it, mark it, take notes, know what the document says. For those people that are appointed as a guardian or a conservator through the court, again, you're going to look to the statutes that are going to talk about what your responsibilities are, but you also need to review the court orders. Any order the court has issued regarding your role, you need to be familiar. You need to be able to understand what that says. And if you have difficulty, reach out to counsel to get help, or you can reach the court. The court generally has someone on staff that can help assist you as well. So for the guardianship and conservatorship, you're reading the court order and the statutes. For the PoA, again, the document is the controlling piece, so that's a big piece of it. And then you should also look at the statute for powers of attorney, so you're familiar with that as well. And remember that a fiduciary always has to act in the best interest and with undivided loyalty to the principal. The medical PoA guardian responsibilities. Essentially, they're going to handle medical care, long-term care. So does the person need at-home care or assisted living or memory care? All of those things are going to have to be looked at. And then the housing decisions, if they're going to be able to stay at home, can they stay in the house they're in, or do they need something that has less stairs kind of issues? So, but when the principal or when the agent is looking to make those decisions, they always want to look at, say, what does the principal want? What were their wishes? And what is in their best interest? Those are the two primary things that you're supposed to be considering when you're making these choices. And you will honor the principal's wishes whenever possible. You don't want to make changes that don't reflect the principal's life wishes unless there's a safety issue. So if there's a situation where the person is no longer safe to be at home and you have to move them to a facility, that's one of the hard decisions that a medical POA or a guardian has to make. And you have to be prepared to make that decision, make those difficult choices at times. But safety is obviously a primary consideration. And again, as you're going through this process, once you know that you're in this role, some of the things you might want to look for is there a living will exist? Is there do not resuscitate orders? Is there 5 wishes completed? All of those documents, if they exist, I would recommend that you get a copy of them, you keep that, and you be aware of what your principal's wishes are, because that will help you with making your decisions as you move forward. The need for long-term care, we talked about this a little bit. As far as one of the things you're going to need to be aware of is how is it going to be paid for? Because as you make your choices, what choices you look, or what sort of assisted living choices you choose or skilled nursing choices you choose are going to depend on how is it going to be paid for. Is this person going to need to qualify for Medicaid? Are they going to need to qualify for veterans benefits? Were they a veteran, or was their spouse a veteran and they potentially could get benefits through the VA? Is there long-term care insurance? If there is, as soon as you know that, I would definitely get a copy of that policy and read it, so you know when and if care is needed, what steps you have to take to get that policy to start paying. And then, of course, there's the private pay option. What does it cost out there? I mean, for long-term care is expensive. In-home care, you're probably looking at $22 to $28 an hour. Assisted living, $2,500 to over $5,000. Memory care, skilled nursing, $8,000 plus a month. Long-term care is very expensive. So the ability to pay is a critical piece as you're trying to determine how you're going to handle that issue moving forward. Adding caregivers as needed. Sometimes I suggest that people bring a caregiver in early, to maybe sometimes come in and help clean or whatever. It introduces that care to the principal early. They establish a relationship. They hopefully get to be more involved in the choice of the caregiver. So I think that can be helpful, and maybe it's, a couple of times a month or a couple of times a week. It starts out very small, but they get to build a relationship and get to know each other, and I think that is all positive. And if you can do that earlier when it's really necessary, maybe there's a relationship already started. I think that's always possible. The question about what level of care is needed, there's lots of options out there to get help to determine what that is. Primary doc is a great source. Other family members, obviously, is a good source of information as well. You can go to a professional like a care manager who will come in and do an assessment and tell you what level of care is needed. Or you can go to the county area agency on aging and they can help with that as well. So those are some places where you can go to get help on the level of care needed. Also, once you are appointed, if there isn't a neuropsychological examination that's been done, you may choose to have one done for the principal. So you can better understand where they are in their cognitive abilities right now. And to establish a relationship with a doctor, and then have that person to be available as things change over time. The financial power of attorney and the conservator's responsibilities. Again, either role, this is the person that's handling the money. This is the person that's paying the bills, handling the investments, dealing with the house, dealing with all those kinds of issues. One of the things that person wants to do is avoid any transactions that cause a conflict of interest. If you have something that you need to do and you are concerned that there's a potential conflict of interest, you can always request the court approval prior to taking action. Or you could go to all the interested persons and write up a document that everybody signs on that agrees that this is appropriate steps to take. Either is a good way to get that potential conflict out there and get it dealt with and get approval for things that you need to take care of, whether that is, adding someone's name on the home, or you're going to be loaning money to the estate, or whatever that potential conflict is. You definitely want to be above board and get approval to do that prior to taking action. Obviously want to administer the assets with care and prudence. You want to make sure that if you're dealing with investments, that you're dealing with something that's not high risk, because now the person is at a stage in life where they're going to need the income or the potential principal. So maybe you don't want to do such long-term type investments. So that's something to take into consideration. Another biggie is do not commingle their assets with your assets. Huge issue that causes a lot of problems. You're going to the grocery store and you're paying for things for yourself as well as for things for the principal. Have them run up 2 separate tabs and have 2 separate cards so that you're only paying for those things with the principal's money. You aren't using your card to pay the principal and then paying yourself back. If you have a lot of transactions of paying yourself back, it just is going to cost money to deal with those issues in the long run. One of the things that I always suggest is when you are first appointed and you're taking on this role, whether it's the financial power of attorney or as the conservator, that you prepare an inventory. You get a picture of what assets you're dealing with, what everything is worth, how is it titled, are there named beneficiary, is there debt out there, and then detail on the income, how much a month are you receiving, and what is out there for people. Are they receiving a pension or Social Security or whatever? All of those things. Get that information so that you have a clear understanding about what the issues are. Annual reports. A guardian and a conservator, once they are appointed by the court, are required to do initial reports within 60 to 90 days of their appointment, and then an annual report. Normally, the court assigns that annual report on the birth date of the principal. If you're acting as the power of attorney, you should check the document to see if there is an accounting requirement. But as a practical matter, all accurate records must be kept. If there isn't a requirement for an accounting for the power of attorney, I would suggest, even if you're not going to share it with anyone, that you do it every year and you update that inventory every year so that you have a good sense of how much money is still out there. Is there still sufficient funds to be paying for the person's long-term care? Do you need to be focusing towards looking at Medicaid as an option? I mean, some of those things that going through that process will help you determine any changes you need to make going forward. Keeping your receipts, critical piece. A lot of people forget this one. Even when you're going to that grocery store and you're buying groceries, keeping that receipt. If you are the guardian and conservator, you're potentially going to have to show those to the court. If you are a power of attorney and someone objects to something that you did, again, you may need to show that to other interested parties in the family, or you may at some point need to show it to the court. One of the things I've noticed is when people bring in a bunch of receipts, sometimes those receipts will fade. And so then it's difficult to determine what the purchase was actually for. So I am recommending more and more that people either scan those receipts in or they make a good copy so that they have less issues with fading than what you get at the store. But you want to be able to tell, what you paid for, the date that it happened, how much did it cost. One of the big responsibilities for the financial power of attorney and the conservator is applying for public benefits as needed for long-term care. Going back to the receipts, how long should they be kept? Generally, I would say keep them for 3 years after you've ceased acting as the PoA or after the termination, 3 years from the date of the termination of the conservatorship. Again, we talk a little bit about, and the 3 years, I'm going to go back, the 3 years has to do with the fact that you're potentially could get sued for 3 years within the date of acting as the PoA. So that is the time frame that I'm using there. The audit, we talked a little bit about the court. The court has an audit program where they randomly audit conservatorship cases. The court can actually also trigger you and say that you are required to be a part of an audit because they have something they've seen that they're concerned about. And as a conservator, you're filing your annual report. When you file to terminate the conservatorship, you will file a final accounting. So there will be an accounting all the way through your acting as the conservator with the court system. Interested persons, so other family members, are allowed to object to the final accounting. And in fact, they're allowed to object to any accounting if they feel like the money is being spent imprudently or improperly. If there are no objections, the court will enter a decree of final discharge once the conservatorship is terminated, which then releases the conservator from all liability. A general power of attorney, when does it expire? It generally does not expire. It is, if it is a durable power of attorney, it continues until that person dies or it is revoked. However, you can have what we call a specific power of attorney, such as one that allows you to sign documents at a real estate closing, that essentially it is only good for that one specific event. Or you can set a power of attorney, let's say you're leaving town for 90 days and you need someone to be able to act during that time period, then it's just good for those 90 days. Otherwise, generally, they do not expire. However, they terminate once that it is revoked. So if the principal signs a revocation, that will terminate it as long as the principal has capacity to do so, or the person dies. Once the person dies, that power of attorney has no effect at all. I can't tell you how many times I've seen people go do some additional banking transaction based on their PoA after the person dies. They should not be doing that. They do not have the legal authority once the person's died to do anything. That the PoA ceases to be an effective document at that time. One of the things that you have to be aware of with the power of attorney is financial institutions and medical facilities are wary of using documents that are old. As an example, I had a client that wanted to place his mother in a skilled nursing facility. She had very serious dementia, and he had a PoA. He took it to them. They would not honor it because it was over 10 years old. So we had to go in on an emergency basis and have the court appointed him as the guardian so that he could then place her in the facility. One of the things I recommend is that you should update those documents at least every 7 years. If you are working with a doctor or a facility and they have your power of attorney and they continue to use it, that is a different issue. This was a situation where, these people had never seen this power of attorney and they just brought it in and it's over 10 years old and they're like, we're not going to rely on that. Okay, I'm sorry. Okay, joint accounts. This is what I kind of think of it as do-it-yourself power of attorney. So a lot of people do this. Well, they'll add a family member or a neighbor or a friend to a bank account so that they can write checks and assist them with paying bills all the time or in case of an emergency. Many people that do this don't understand that this also gives them the right to all of the funds that are in that account upon death, because they are now technically a joint account holder. Now this can be held, and they do this to avoid having to go get a PoA. I recommend not doing this, going to get the PoA and having the person added as a power of attorney. That establishes that fiduciary relationship, which means that PoA has a fiduciary duty to do what's in the best interest of the person that owns the actual funds. And then the PoA does not have the right to inherit. So then the person's either by statute passes to their family or it passes via will. And that the only way to overcome that, if there is a person added on that joint bank account, is you have to establish that it was created just for a matter of convenience. Sometimes that's very difficult to do because you have a hard time finding someone out there that can testify to say that this person's name was added just as a matter of convenience. So we tend to say, don't add somebody as your joint owner. Go ahead and do it as the power of attorney. Things that fiduciary can't do. So for the conservator, there's specific statutes about what a conservator cannot do and what requires court approval, essentially, prior to them taking the steps. Number one being making gifts. So the conservator cannot take and gift, $10,000 to someone without the court approving it first. They cannot create, amend, or revoke a trust. So they can't create another entity, i.e. a trust, and deposit assets into it and control it that way. Not without court approval. They can't change beneficiaries. So they can't change beneficiaries on a life insurance policy or on a bank account. They can't amend, make, or revoke the person's will. But again, you can remember that each of these things, if you need them done, you can get it taken care of. You just have to get the court's approval. I had a case where we went in on an emergency basis and asked to change beneficiaries from son to a significant other. And son and significant other were working together. Mother was essentially dying. And so we went in on an emergency basis and got them to change the beneficiary so that the assets that were in that, or the money that was in that asset could pass to a significant other rather than to the child, based on the wishes of the family. Again, there are additional things that the conservator should not do. And so you should always check that statute and know that specifically. As far as the agent under a financial power of attorney, again, you're going to be looking first at the document. What does it say? What does it allow? And then there's specific things, again, that unless it's specifically allowed for in the document, the financial power of attorney does not have the authority to do it. And they're similar. You can't create, amend, revoke, or terminate a living trust or an existing trust. You cannot make a gift. You cannot create or change rights of survivorship or a beneficiary designation. You can't change a deed. You can't delegate authority. So those are things that you specifically want to talk about and address with your attorney to make sure, do you want your power of attorney to be able to allow this or not? And generally what I talk to my clients about when we're talking about creating powers of attorney is you may want your spouse to be able to do some of these things, but when it gets to the alternate, maybe less so. And you can draft it that way. So turning to the guardian, and a guardian, again, is the person that decides where the person's going to live, decides their medical care, that type of thing. So the things that require court approval is if you want to move the principal out of the state. If that's going to happen, you have to have court approval to do that. If you're going to be paid a fee for acting as a guardian and there is no conservator, you have to have the court's permission to do that as well. You have to have the court's permission to revoke a medical durable power of attorney. Generally, that happens when a guardian is appointed anyway. It's generally part of the order and the court generally grants it because we generally don't want two different people with having the same authority to make medical decisions. It's just not very effective as a practical matter. So generally, the petition will ask for the revocation of that. The ability to place someone in a mental health institution or the facility to include treatment for substance abuse, again, you have to have the court's permission for that. The ability to commence and maintain an action for dissolution of marriage or legal separation. You have to file a specific petition and ask the court's permission to do that. And that's something that a power of attorney cannot do. That has to be either the guardian or the conservator has to bring that action. And it is required for, if a conservator is going to do it, it has to be approved by the court there as well. Same thing with the consent to an adoption or a marriage of the principal. The guardian cannot authorize that, but they again can ask permission from the court. Guardians and significant others. We're seeing this more and more where the protected person has a significant other they may not be married to. And the guardian would have the authority to decide whether these people get to continue to see each other. And again, the primary issue for the guardian to take into is what is that principal's wishes and what do they want. But inevitably, the guardian has that final decision. And we always recommend, if there is a significant other out there, is to give them notice. If they have been living together in the same house for the last 6 months, then you are required to give them notice. But I have an example where we had a couple that were essentially together for 17 years, and we had to go in and ask the court to add them as an interested person because of the long-term relationship. But there isn't a guarantee that the family will give you notice. Compensation. Can you get paid? For guardianship and conservatorships, the Colorado law allows compensation under 1510-602. If there's no conservator, the guardian must seek approval for compensation. And both the guardian and the conservator, when they file the petition asking for the appointment, they have to tell the court at that time how much they're going to charge. If they do not disclose it in that initial petition, then once they have determined they want to get paid, then they must file something with the court to update the court as well as all the interested parties what they're going to be charging. Now, if there's a conservator, the conservator may pay the guardian a fee without court approval. However, there would still be, I would believe, requirement that the hourly rate be approved through the petition, or some other petition must be filed to get that hourly rate approved. There is no explicit requirement that conservators must obtain court approval to pay themselves a fee, but I would recommend that certainly you have to put it in your petition of your hourly amount, and you're obviously going to be disclosing it when you do your annual accounting. And of course, that would give people an opportunity to object if they wanted to. As far as an agent, a power of attorney, you need to first look to that document. Does the document allow for you to pay paid or not? So that's your starting point. Some documents specifically disallow it. It's not uncommon for families to say, I don't need to pay my child to be my PoA kind of thing. But if the document says nothing, then the Colorado allows compensation under 1514.712. It must be reasonable. Taking a percentage of the assets, the value of the assets, is very disfavored in Colorado. It should generally be hourly. The hourly rates sometimes can vary. You can say, okay, if I'm going to be cleaning out the house, I'm going to charge a lower rate than if I'm dealing with the attorney or dealing with the accounting kind of issues. And you have to remember, if you're taking compensation as reportable income to you, you have to report it on your tax return. The guardianship and conservatorship, again, same thing, where they're going to be talking about, the rates and changes of compensation must be disclosed to the court. And again, if you don't disclose it in your initial petition, you need to file it for approval later. Reimbursements for expenses is allowed generally in all powers of attorney as well as in the guardianship and conservatorship, but it's subject to the same requirements of accurate records. Always, always, always keep your receipts. Your time records are needing to be kept as well. If you want to be paid, then you need to keep track of your time. And I recommend that you keep your time the same day that you do the thing, whether it be, dealing with bank records or, talking to someone at Medicaid or Medicare or, talking to the facility. You want to keep the date that you did the work, what it was that you did, to enough detail so that you can explain it to someone else at some point in the future if necessary, and then the amount of time that it takes you to perform that service. You don't want to group a big block of time together. And this is an example here where you're seeing the review bank statements for an hour, input data into the accounting software, an hour and a half, and then calling the bank for point 2 versus, glomming it all together and just saying banking stuff, because banking stuff doesn't give you much information. It would be hard to say what that was really for. And the first thing I would look at that if I saw that was that drive time to the bank? Did you actually have to go to the bank? It's hard to tell. So I think that breaking it apart is great. I mean, I would recommend to my clients, buy yourself a binder that you keep together, that you write down your time every day, what you did, how long it took you, and then you can add it up later. But keeping it every day is the best way to do it. Otherwise, it's just too hard to remember what you did last week. Going through some of the pitfalls that you'll have involved with this. First is life estates. It is a popular Medicaid planning tool to prevent the state from recovering a house once the owner passes to pay back Medicaid. The original owner retains the right to live in the house for the rest of her life. And then once they die, the person that is named on the deed records the death certificate, and then the house transfers to them. The issue that you have is it does require preparing a deed. The remainder persons are not fiduciaries to you, so they do not have any duty to you based on this deed. And with a life estate, you cannot bring a partition action, so you cannot break this apart by a partition. Best way I can give an example of that is if you are a joint owner of property and you're trying to get the property sold and your joint tenant doesn't want to, you can bring a partition action to force the sale of the property. I had a client where this became an issue. We had done just this. We had created a life estate in her home and named her 2 daughters as the remainder beneficiaries. And she wanted to sell this property and to move into something with less stairs, and they refused to do it. And it became a big problem for her that they would refuse to allow her to do this. And we were surprised, to say the least, that it became a problem. But we eventually got them to agree to just transfer the house back into her name, which was very, very unfortunate because the 5 years was almost up and almost gotten to the point where if she needed long-term care and had to go through Medicaid, the house would have been protected for the 2 daughters, but they were unwilling to do anything else. So that is what happened in that particular instance. But because we couldn't bring a partition action, we couldn't force them to sell, but they did voluntarily agree to transfer the house. Another way to avoid this is to establish a trust and put the house in a trust and deal with it that way. When to stop driving. This is a big issue in families when you're trying to get an elderly person to stop driving and they don't want to. Generally, I tell everyone start with the primary physician. They can write a letter to the state and revoke driving privileges for someone. So that's one way to handle it. Other ways I've seen is to, disable the car so it can't be moved and leave it there. Sometimes that's reassuring for the principal that they still have the car, it's still there even though they cannot drive it. The other thing is obviously to remove the keys. But again, this is a safety issue, and sometimes this decision just has to be made regardless of the principal's not liking the choice that is being made. The one thing that you can talk to the doctor about is this simply we're eliminating just night driving, and you can put some kind of restriction on the driver's license. That's something to worth researching as well. Limitations on the POAs. A power of attorney does not take away a principal's right to make their own decisions until they are incapacitated and they are unable to do it themselves. So a power of attorney can say that, your adult son has the ability to make decisions at the same time that you do. Now, if there's a conflict regarding that the principal and the agent don't agree about what decision should be made, the principal's wishes control as long as the principal has capacity. The power as attorney can be considered to be revoked as soon as any time as the principal retains the capacity to revoke. So if there's a dispute between the dad and son, we'll do it that way, then a lot of times whoever they're trying to use it will deem that power of attorney to be revoked and will no longer be effective. Facilities are reluctant to admit a person against their will with only a medical power of attorney in place. It is possible, but it can be difficult. The solution, if you run into that problem, is to file a petition with the court to appoint a guardian, so that then the court is making the decision that, yes, you have the permission to place this person, and you have the full authority as the guardian. So the distinction between a guardian and the POA is that once a guardian and a conservator are in place, you may have to confer with the principal, but ultimately you have the decision-making authority, and they can't override, the principal can't override your decision, essentially. The commingling pitfall, and we talked a little bit about this earlier in the presentation, and it's just easier to pay for my account because I have the debit card with me or whatever. This can cause so many problems, especially if at some point you're going to have to be qualifying for Medicaid, because then you're going to have to go back and prove every time you paid yourself back for this that it was really for an asset related to the principal. I cannot express strongly enough that don't do this. Have that separate card, keep the money separate. I mean, there may be instances, say that you need to loan money to the principal because you're now sold an asset, you're waiting for the funds to become available, and you need to pay, say, the nursing home bill. If it's a short-term fix like that and you're paying a single bill, that would be one thing. If it's going to be longer term, then I would really suggest that a promissory note be written and it be spelled out specific detail about how that's going to happen and how you're going to get paid, and are you going to be paid interest. I think that is the best way to handle that, but the best scenario whenever possible is simply not to commingle in any way. Helping granddaughter with college. This is another one that we've seen a lot of. This can be either by grandmother paying directly for granddaughter or co-signing on the loan. Because on a student loan, you cannot bankruptcy out of owing on a student loan. So it can be a very big problematic. And I would generally suggest not to do it. Again, to help for guardianship and conservatorship, it would require a court's approval because it's a gift. For the POA, you're going to be looking to say, does the POA allow you to gift or not? And that's going to be a really specific clause within the document itself. And you have to remember that you're going to have that look back period, that 5 years, to see if the gifts were made. And you have to remember, if the gift was made, and let's say it's $100,000 just for a round number, and you need to qualify for Medicaid within the 5 years and you gifted $100,000, Medicaid is going to say you still have that $100,000 and you will not qualify for care until you privately pay $100,000 worth of benefits. And the problem is the money is gone, and if the person cannot pay it back, you've got a major problem. There is the option to try to file the Medicaid application based on a hardship because of this situation, but it is a problem waiting to happen. So if you're going to do any gifting, be sure that you have analyzed and reviewed that long-term care situation. so that you know whether you're going to have a problem with Medicaid in the future. The other thing I want you to, that people get confused about, is because the IRS allows you to gift the $15,000 a year without having a tax benefit, does not mean you get to do that for Medicaid purposes. Medicaid doesn't care about that rule. That's a tax rule, has nothing to do with Medicaid. If you gift the $15,000, it's going to cause a penalty. End of life decisions pitfall. This is, knowing what the principal wants and how they want to make their end of life decisions. Again, first thing is you want to say, does the POA have the power to withhold treatment? Check the document. That's the first place you need to go as the POA. As an any interested person can ask the court to modify the POA or the guardian's authority to prevent them from being able to make end-of-life decisions. So someone could file and say, I don't want the guardian to be able to make this choice. I think they're choosing wrong, or they can intercede in it essentially. And this could include a significant other, or even a friend could file for this. If it became a decision and you're looking to essentially end someone's life, that would be filed on an emergency basis, and the court would likely order the principal to receive treatment pending the disposition of the case. I would expect that a hearing would be set and evidence would be required to determine what everyone will believe is in the best interests of the principal and what the principal's wishes would be. Again, that goes back to those original documents we talked about. Is there a do not resuscitate order? Is there a living will? Are there 5 wishes? All of those things are something that you want to take into effect as you're making these kinds of decisions. But you definitely want to, once you know you're appointed, you want to have this conversation with the principal, hopefully if possible, and you also want to talk with the family, so you have a sense of where everyone stands on this issue. That's the end of my presentation. I will now open it up to questions. I'm going to stop the share. Okay.
All right. And Anne, we have quite a few questions.
Okay.
First,
go ahead.
Yeah, go ahead. If you can open up the question and answer.
Okay.
Box.
Well, a list of fiduciaries in Boulder County. There are a lot of people that will do this on a professional basis, and I would have you probably reach out, but I don't know that there's a list posted somewhere that I could give you. But if you're looking for professionals, if you want to reach out privately, we can give you some options. Who audits trust officers at the bank? Who holds them accountable? Trust officers, I guess the first thing that you would look at would be the trust agreement itself, because most likely they're required to do some kind of accounting that would be going to the people that, one, the beneficiary normally, and then potentially other interested persons. And if they have issues, they can always bring a trust action to have the court look at it. Is there a registry of trust violators? Not that I'm aware of, no. How about if the principal is a couple, meaning both spouses elected you as the fiduciary in the same document? I would not do the same document. I think that they each need to be separate documents, because generally they're going to appoint each other first, and then aren't necessarily going to have the same alternate, and aren't necessarily going to want to be giving the same thing, so I wouldn't recommend a joint POA. How do you stop for-profit guardianship abuse? And why the court-appointed guardian is not certified in their jobs? There's no qualification to explain this. The guardianship, and I mean, if you have an issue with what someone is doing in a guardianship, then you need to petition the court and have the court review the guardianship. Ask that the guardian that is appointed their guardianship be terminated, potentially asking for someone else to be appointed as the guardian. And deal with that through the court system. That is going to be handled through the courts. How does a person who has been POA pay bills and do other financial things for the person they are POA for after they die? They cannot. After the person dies, then you're going to be turning that role over to whoever is in the will, essentially the personal representative of the executor. If the estate is really small, it would be handled by a small estate affidavit, but the POA has no power once the person has died. Why are guardians paid out of an estate? Why are they not paid from the state? This way, no theft of property will be stolen by the guardian. There are not funds in the state to pay for guardians at this point. I know it's been an option that has been looked at But as far as I know, nothing has been established, so there are no funds from the state to pay the guardian, and that is why it is paid out of the estate. How much does it cost to hire a fiduciary? That depends on the fiduciary and what you want them to do. So you'd have to talk to them specifically. I guess for Luann, I don't know what your specifics are, but I think that would be something we'd be better suited for a specific question to address an issue on a particular person. What are the 5 wishes? 5 wishes is essentially questions that it's a program that's out there that asks you specifically about, how you want your end of life experience to be handled. That's an easy thing that can be handled by Googling it or, checking online. If you have specific questions, you can ask me directly after the presentation. In opening a bank account under a trust. Generally, the bank is going to require the trust documents to open it because they want to make sure that this person has the authority to actually open the account. So that is necessary, and I would consider it okay, yes. What is the fiduciary when there's a reverse mortgage in place? I would say that the fiduciary needs to, read the reverse mortgage, understand what would trigger the paying back of the reverse mortgage, understanding what is available. Is this something that you're getting, can draw it out in lump sums? Is this something you're getting a monthly amount to live on? They're going to need to understand what's going on with the reverse mortgage, what options are out there, and when it needs to be paid back. Why are good qualified family members not able to take care of their parents? Again, that is going to be a specific situation because I'm assuming you're talking about guardianship and conservatorship, and that the bottom line for that is the judge is going to have the final decision about the appropriate person to act in those roles. If that's where you're going is through the court system, and the court is going to weigh again what they feel is in the best interest of the principal, as well as a protected person, as well as what their wishes are.
All right. Wow. that was rapid fire answers. I love it. It was great.
One question I'm not sure I answered that what came in early was that can the PoA also be the personal representative of the executor? And I wanted to answer that question. And I wasn't sure I covered it in that when you're choosing your fiduciaries, you don't have to have 7 different people. If you want, they can all be the same person, or you can, generally what I get from family members is they try to divide some of the roles up so that one person doesn't have to take on all of the heavy duties, but they can. So answering that question.
Well, fantastic. Do we have any other questions? Anyone want to sneak one last one in as we have a few minutes? All right, I will just to answer one of the questions that came in that I answered over typing was regarding the slides availability. Anne, would your preference be for them to contact your office or contact Senior Law Day?
Senior Law Day would be fine.
Okay, so please go ahead and contact us at Senior Law Day to request a copy of the slides after the fact. Again, we had a couple of questions come in that were a little more specific, in which case please look at that free virtual legal clinic at the Boulder Bar Association. That's going to be the best way to get if you have a very specific issue to your family. And we had 2 last questions come in.
I saw that. So how does a lone person find help? Again, generally, if you don't have family or close friends in the area, a professional is a good option. And generally, if you were going to work with my firm, we would generally give you, 3 or 4 names to reach out and have you establish a relationship with that person that you're asking to act as your professional power of attorney. especially if it's going to be medical, because they're going to need to get to know you. And what I always suggest is, you may not need them today, but you may need them to act a year from now. But I think that it would be helpful for you to be in contact with them like once a month until they actually assume the role, so you establish that relationship and that trust between you, and so that they get to know you, and also they know what's going on in your life, so they know when they do need to step in. So you're looking, again, for those professionals. And again, that help in finding a fiduciary, if you have access to the internet, which you do since you're at this meeting, is, Google professional fiduciary, professional power of attorney, whether it be medical or financial, or professional guardian conservator, and put your city or your county in there, and you will find people that do that for a living. And then meet them and interview them, and find somebody that you are comfortable with.
Well, fantastic. Thank you again so much. I know this is a challenging format for everyone, but we are so grateful that you and your firm handled this so beautifully and made this go so smoothly for our attendees.
No problem. I'm glad to help.
I am going to go ahead and share my screen once more so that we can look at our sponsor slide as we close up, and just thank you everyone for coming. Our next talk again is the Medicaid long-term care talk. I know that was mentioned today, and one of the neat things about Senior Law Days, particularly in this format, I'm listening in on a lot of different talks and seeing how interconnected all of this is. So I would highly recommend people to attend our next one as well. So have a great afternoon, everyone, and thank you again, Tam.
Thank you. Enjoy your afternoon, everybody.